this side.
Yeah, you can record it, I think, yes. Yeah.
Sir, for the internals, can we refer to the material that you have shared with us?
Yes.
Like, will that be enough?
Yes, this should be. If you are only relying on those materials, that should be enough, right? But I will also be sharing with you the PPTs, right? So first unit PPT, as and when they will be completed, I will send them in total. So far I have only sent something around 44 slides, right? I've shared that, but the overall PPTs I will share. Those will be sufficient. The books I have already shared, that will also be helpful. I will also be sharing few more additional readings, right? To that extent. Chalo.
Okay, sir. Thank you.
Yeah. If you want to have more readings, otherwise also you are going to come to college. There are few reference books which you can correct from the library itself, right? Most probably everybody is going to have classes in the physical like mode in the college, right? So this is going to be our last online class, right? So okay, chalo, we have sufficient numbers now. We can start. Any doubt from the previous topics that we have covered? No doubt. It generally is the case, right? But no worries. Okay, so let me share this slide. And we have to refer to the functional theory. We have covered the fictional theory. We'll start from this. Just a second. Okay. Sure. So, and we will take the attendance in the end, right? Let the other student join in between. And so if there are questions, do refer to those questions. Now, what we have referred in the previous classes when we were discussing about subjects, and I said that like there is a theoretical part of acknowledging a particular subject, right? A realist believe that since law is created by states, the ultimate and the sole and the primary subject of international law is state all alone, because for individuals they are merely acting as object, for other entities they are merely object, because their rights, duties and obligations are influential to the rights and duties and obligations that has been assigned to the respective states which they belong to, right? Then there was another theory uh, which says that ultimate impact of rights, duties and obligations are individuals. Much like in the domestic setup, individuals are the concern of laws. For international law as well, the concern and ultimate like influence is of individuals altogether, right? And they said that the rights and state merely act as a fictional and abstract term in between, right? They just represent the will of those particular individuals. So that is where the fictional theory comes into picture. I have already referred this in the early class that it was theoretically sound and logically correct as well, but practically impossible. Much like the realist theory, where we were discussing about that reparation case, which outrightly reject the very notion on which realist theory, like base its argument. Similar with in the case of fictional theory, we have found out that in Mavromatis case, it is not just the individual. There are some additional rights, duties which are assigned specifically for state, and particularly in their dealings with diplomatic like rules, in their dealings with raising a case against another state or a citizen of another state. There is a requirement of an state altogether relevant, right? So you cannot disregard the existence of a state by claiming that the ultimate impact lies over the individuals in both scenarios, in domestic and international scenario, right? Because there is an exception to this particular rule. Diplomatic role laws have no relevance of individuals altogether. It is a concern for state altogether. And therein, I was saying that in diplomatic law, though it's not part of our syllabus, but you have state-specific conventions, treaties, obligations, and then you have international organization specific, like conventions. With respect to state specific convention, I have referred to you VCDR, VCCR, right? Convention on Special Mission, 1969. Then you have immunities that has been granted to like internationally protected person, including citizen, 1973. So those are specifically state-specific conventions that have acknowledged immunities, right? Diplomatic immunities, consular immunities, or for governmental officials, state officials, right? For the last two categories, you will say that collectively it's about the state officials. Then I said that within this, there are two concepts. One is ration persona, another one is ration materia. Within ration persona, complete immunity, right? So by being in that particular office, you have been assigned with complete civil criminal immunity for that matter. But when it comes to ration materia, the immunity is only with respect to the acts that were supposed to be performed by state. So those acts which have been performed on behalf of a state will bring out certain immunity to you or privileges to you. One of such is that you will not be arrested. But in counselor's case, if it is a grave offense, he can be arrested or she can be arrested. Right? What is grave offense? Not decided. How will you reach to this particular conclusion that there is a grave offense? You have to look into the domestic setup. In India, we have this concept of cognizable and non-cognizable offense. See how CRPC gets related to this concept of international law. So that particular distinction is quite relevant. Within cognizable and non-cognizable, one of the criteria that we follow is grave offense, serious offense. So if it's a serious offense, the criteria for serious offense is that it is equal to 3 years or it is more than 3 years, equal to or more than 3 years, right? For any offense which is not serious, it is less than 3 years. But that's not the only criteria. We know this particular fact as well, right? Because say, for example, like being member of an unlawful assembly, you are not given punishment which is more than 3 years. It's less than that. But still, it is a cognizable offense. Police can arrest you. There's a very interesting provision in your IPC, section 269, 270. When you have this habit of transmitting a particular disease, right? It was very helpful during the case of COVID, right? Then you will be caught. The punishment is less, but it is being treated as cognizable. So it depends on the severity of a particular offense as well. At times the offense is going to be very serious, yet the punishment is less, and the punishment is also high. But state do not want to enter. Your entire chapter with respect to family matters, that is part like section 490, somewhat around at that point, 95, all those things, right? Therein, it is not a cognizable offense, it's a non-cognizable offense, right? Then there are certain new innovations which have been also coming, right? One of the innovation is your section 376B, during judicial separation. If like at the instance of the wife, the offense will be treated as a cognizable offense. If she complains, then the offense will be cognizable, right? There is this Child Restraint Marriages Act. Therein also a very important section is there. So, but that's part of CRPC, right? So when the point is grave offense, how will you determine? Your own domestic setup will make clarity to this. Now you can see how state practice is also important, right? So your state practice is equally important. Most importantly, when we will be studying about sources, like there was a very interesting case, French case is that I'm not recollecting it now, but there is a concept of like the psychological element of acknowledging like a custom. Right. So that particular case is quite important, and therein the reference was made to the judicial pronouncement of that particular state, which was missing in their decisions, and that ultimately proved against the state of France. It's between France and Turkey, right? It's a very relevant case, and the court found out that the necessary opinio juris Saib necessites was not present in the argument which was raised on behalf of French state, right? And ultimately it went in favor of the Turkey. But we'll refer to that particular part later on when we will be looking into the material part and psychological part of treating a particular practice as custom, right? Because merely an existence of a particular practice alone will not serve it as a custom. There are certain other requirements that have to be met, and we'll refer it in Unit 2 classes, right? Okay, so functional theory is the next theory. Now it says that there's a middle path, there's a moderate approach that can also be taken into consideration, because over the last few years, 50 years since the making of United Nations, the world has witnessed emergence of various organizations, not international organizations, various organizations. Those are regional, intergovernmental, right? Those are treaty based, like United Nations. So these organizations have emerged. Why they have emerged? Because state alone cannot have, like this state alone cannot have uh, like coordination, a proper coordination among themselves, right? Somebody has to be there as an international institution that can regulate their conduct, that can coordinate among them, right? So that's where international organizations plays an important role. Similarly, the status of individual, which was missing for a greater part of the history of international law, is also gaining importance, right? And in the form of their reference in human rights treaties, in the form of the Rome Statute, right? Prohibition, complete prohibition for commission of those prohibited offenses that has been referred in the Rome Statute, and individual liability over there is being conveyed. So individual is also coming. Non-state actors, they are also becoming relevant. I have already given you an example yesterday with respect to the state of Sudan, right? So a claim of non-entity before an international arbitration tribunal was acknowledged between a non-state actor and the state, right? Was acknowledged. So non-state actors have been emerging. So this has been giving, like, this must be acknowledged. You cannot be rigid and come up with different logic as it has been made in Riller School, which says that ultimately it is state who is entering into those conventions. Without their approval, the role of individuals, non-state actors, is limited. Realists believe that. Fictional says that ultimately the impact of those entering into conventions, treaties, is the individuals. So without individual, there is no such concept of state altogether. It's a fiction. It's an abstract term. So individuals are important, but functional theory says that everyone is important, right? And it's a moderated approach, right? It does not uh, goes with what has been argued on behalf of the realist and the fictional theorist, right? So this argues that there has to be relevance and reference of other entities as well, non-state entities, individuals, international organizations. They are also playing crucial role. Now I can give you an example. Now United Nations has formulated a privileges for itself and its officials. Like there is a convention on privileges and immunities of United Nations, 1946. There's another document, Convention on Privileges and Immunities for the Officials of United Nations, 1947. So they have the capacity to enter into certain forms of agreements as well with other member states. Now, those privileges and immunities are respected by other states. In fact, they have been referred in reparation case as well. When, like in reparation case, it was said that whether United Nations is an international organization or not, they said yes, it is, because of the reference of Article 1 and 2 of the United Nations Charter. How will it serve its purpose and fulfill its principles when it will not be assigned with that particular role? Another classical example is its reference into the domestic law itself. Under Article 104, if you look, I will just share that particular part of UN statute. You will find out that under 104, they have given this particular aspect, the local aspect, that your domestic law of every member state will acknowledge the role of this particular organization, right, for its fulfillment of function and principles. 104. See, the organizations shall enjoy the it shall enjoy in the territory of each of its members such legal capacity as may be necessary for exercise of its function and the fulfillment of its purposes. So this is acknowledged within the text of UN Charter that the member states will recognize the existence of this particular organization for exercising of their functions, its functions and its fulfillment of its purposes within the legal realm of that particular state. So you will have organization of United Nations and its organization placed in various parts of every country. This is a mandate upon its member state that they should acknowledge their existence in the domestic setup under Article 104. So similarly, you will have Article 39 of ILO. Right. Therein also this is available. So international organizations have been gaining importance. References have been of theirs have been required to be made within the domestic setup. Article 104, 39 of ILO, 104 of UN Charter, ILO International Labour Organization, right? So they have been emerging, and this is not something that only United Nations came into existence. The reference of international organizations comes into picture. This was already prior to United Nations. You had League of Nations, right? You had International Labour Organization. You had Red Cross, right? Non-governmental organization, which was also acknowledged. And then many other associations were also formed, and they were suggesting for the process of codification. ILO, ILA, International Law Association, right? It played significant role towards the codification process of international law, right? Various other organizations were also emerging. The important aspect for emergence of organization is that it is acting as a regulator. It regulates the conduct of states. It is acting as an organization that is fulfilling and mandating consensus. Reaching out of a particular solution is consensus form. It is not a unilateral act of any particular state altogether. So organizations have been playing significant role to that particular extent. Similarly is the case of individuals. So it is not something which is merely an object, which is what the realists believe. It is in fact playing a crucial role, particularly with the development of international human rights law. With respect to this Rome Statute, so relevance and role of individual is also gaining importance, not at the level of international organizations and never at the same extent to what state have been receiving, but at least there is an effort. Non-government organizations, all of them. So these significant changes which have been witnessed within the domain, larger realm of international law, they must be respected. Right. So this is where functional theory comes into picture. They believe that there is a proliferation of new participants in international law, right, and in their international relations. So once you become a legal personality, this is something which we have covered earlier. You will be ascribed with certain rights, duties, obligations. You will be provided with this particular right of bringing a procedural claim as well, right? So this is important. So international organizations, there have been a proliferation of them. It is not limited to states. Individuals are also joining there, and state international organizations are also joining. Non-state actors are also joining. Now, what they've been doing, they've been influencing international law, right? Which is primarily a source, primarily a realm of only state. They were influencing in international law. Now, it is not just the influence of state all alone. There are influence of international organizations as well, right? Who have been playing significant role in the manner in which we have been understanding international law, right? There is these international organizations. There are regional intergovernmental organizations as well, like European, European Union, African Union. They are also playing significant role to the development of international law. So once you have been acknowledged as part of international law, you have been significantly influencing that lawmaking process, right? Either you are contributing directly or you are contributing indirectly. So you are the realm of international criminal law vis-a-vis state liability has a turn with respect to individual, right? If anybody who has been found doing those prohibitory acts that has been referred under Rome Statute, they will be persecuted, not by any particular state, or its legal system. They will be persecuted by an apolitical, non-biased entity, which is your International Criminal Court. There is a proper mechanism there afterwards for it, laid down under Rome Statute. So prohibited for an individual to perform those particular offenses, and accordingly a procedure method for bringing out justice to the world, right? And that's why whenever you will be studying about international like criminal court, refer to the remarks of then Secretary General Kofi Annan. It's a very powerful remark that he has made, though the ultimate reality is not in sync with what he was opining, but it's a very important reference that he has made, right? And the recent trend is that states are reluctant and they have raised doubts. In fact, they have moved applications to move out from this particular membership of ICC. So, but these are all parts of international developments, right? Politics is also playing crucial role. Their argument is that their specific leaders have been targeted. Like majority of those cases are against African states and their heads. So, and it's an important aspect, important argument, because you cannot, when you're claiming yourself as an apolitical, unbiased institution, what you have been covering over there is this particular fact that you are acting it in the fair manner, which is alleged by these particular state as not being fair, right? So this is where functional theory comes into picture. Now it says that various entities which can be called subjects under international law are emerging, and they must be regarded as subjects of international law, right? Now, so far, this particular theory seems to be consistent with the current situations, right? And therefore, functional theory can be regarded as the correct theory in this particular regard of identifying subjects of international law, right? You need not have to go by that rule of realist that it is state-centered. They enter into treaties, they make customs, right? And objects and other entities like individuals, non-state actors are merely objects. It doesn't agrees to that particular view of this school, fictional school, that ultimate impact of lawmaking either in domestic setup or international setup is the individuals. So individuals shall be treated as the preferred source of international law, and everything else centers around them, right? Which is rightly rejected by Mavromatis case, realist school rightly rejected by your reparation case. Then comes the functional theory, that it acknowledges the role of those new entities as well, right? They've been influencing laws, they have been participating in lawmaking process, right? United Nations is participating in its lawmaking process, right? They have been influencing laws as well through their recommendations, suggestions. There's a sixth committee, right, which listens once the International Law Commission suggests or submits a particular draft in respect to codification of a particular area of international law. It has been sent to the sixth committee, right? And that particular sixth committee ultimately frames it in a proper manner. That's a legal committee altogether of United Nations. So they've been playing significant role in the lawmaking processes of international law as well, particularly its codification. So the learning is on the basis of these theories is that under international law, personality is pragmatically created, treated as a presumption, unless and until there are contrary provisions to that particular extent. So any entity can come before international forum and say that I have international legal personality, provided it cannot be rebutted, right? So this is where the subject of international law will start. The first subject of international law is our international organizations, right? Now, we have already referred this, but some aspect of this, as and when the modern states were emerging, there were significant development in international law order, right? Growing number of sovereign states demands international cooperation, right? And this has largely been done in the later half of the 19th century, when efforts were made on behalf of various entities towards, just a second, yeah. So when efforts were made on behalf of various entities towards bringing consensus. Say, for example, efforts of individual scholars suggest, like compelled international or certain organizations like International Law Association, Deloitte International, and the Harvard Center for International Law to bring a case of codification of international law. And they accordingly made efforts. They created like an awareness amongst the diplomats, they formulated various conferences, supported international organizations with their rough draft as to how they perceive what kind of institution will be formulated, what role it will be conducting with respect to codification of international law, emergence of concepts like progressive development of international law and its codification, which many states believe are like one and same. But then we have justifications also coming, which suggest that both of these two concepts are different, right? Uh, so, so there were efforts made in the later half of 19th century, right? Then by the time 20th century came, this resulted into the making of various important developments. Say, for example, in 1863, the Red Cross came into existence, International Committee of the Red Cross. So much of wars were witnessed by Europe. So much of loss of life, properties were taken place. A concerns were also realized that the humans and their rights must be protected. During wars, just or unjust war is not something which is relevant. The point is, because of those wars, there are losses suffered by humans, and those losses must be taken care of. That ultimately resulted in the development of humanitarian law, right? International Committee on Red Cross largely supported this particular cause, and thereafterwards played significant role in the formation of various conventions, including the Hague Convention, 1899, 1907. Right, it had played a very significant role over there for its formulation and adoption. Right, so and with respect to various human rights conventions later on. So very relevant. So there is a concern for international cooperation emerging. There were attempts made with respect to how to regulate international affairs, and this was formulated in the forms of various conferences that took place. Right, suggestions were sought, and it ultimately resulted into the making of certain associations. International Law Association is one, Deloitte International is another one, right? So they made certain efforts, influenced governments to come up with like certain action plans, and played a very significant role to that particular extent. Now that ultimately led to the making of internationally acknowledged organizations. These were organizations and associations which were sponsoring a cause for, for consensus reaching, which is sponsoring a cause for cooperation, which is sponsoring a cause for regulations, and that ultimately resulted in the making of international organizations. Why international organizations? Because state acknowledged this. Now you had, and it was formulated on the basis of treaties, agreements. There came a very interesting organization, International Labour Organization. India is one of the founding member of this particular organization. League of Nations got established, and with its failure, also the world did not dishearten. It worked further and filled out certain lacunas, made certain corrections, which ultimately led to the making of United Nations, right? And this is how the relevance of international organization only grows there afterwards. Since the making of United Nations, it is only growing. There's no moving backward toward this particular requirement of role of international organizations since then, right? Economic organizations have been emerged now. WTO, you have IMF, you have World Bank. Many other organizations have emerged, regional organizations in the form of SAARC, right, in the form of ASEAN, in the form of European Union, African Union, right? So they have been also coming, and it's very important, right? The role of these regional institutions is also becoming important. How they are going to be incorporated within the brackets or meaning of international organization is something that is required to be seen, because there are certain criteria that have to be followed, and we'll look into those particular criteria as well, right? Now, this paved way for emergence of international organizations with the formation of international associations, organizations came, and these institutions or organizations resulted in the formation of various agreements, treaties, right, declarations, conventions, right, amongst its members, within and amongst its members. Many a time they leave option for like being member to those particular conventions open for others as well, those who may not be uh, participate in the or participating in the original making of those particular conventions, but they may have be interested in becoming party to such treaties later on. Right. This is always available. Many of the treaties, if you'll see with respect to say, for example, there are numerous numbers of water conventions, water related treaties that have been formulated. Right. They can be, and they have the option of acceptance by others as well, those who are interested with it, with its obligations, many other treaties, right? So, and you also have within the treaty the option to move out of such obligations as well. So it's open for states to join. It's open for states to leave as well, right? So we will refer to that particular part in the coming, classes. So now they have entered into certain agreements. This is the convention which I was referring earlier, Convention on the Privileges and Immunities of United Nations, 1946. There is another convention on privileges and immunities of officials of United Nations, which is 1947, which is equally important, right? So they have gained not just this position of influencing law, making law, supporting law, and bringing cooperation among states, but also the position of entering into certain agreements with others, with states, with non-state members, actors. That particular capacity has also been attributed to any entity that claims to be an international organization. If you are an international organization, you will have a statute first. You will have a constitution based on which your establishment is recognized. It will be made on behalf of all the states through a treaty. Then you will have certain functions, you will have certain privileges, you will have certain immunities granted, you will have the capacity of entering into treaty, you will have the capacity of enforcing that particular treaty as well. When we studied reparation case, the treaty and its existence was acknowledged, and within the provisions of UN Charter, it was also acknowledged that it has a certain role, functions, power to perform, right, its duties and obligations that has been casted upon it. But at the same point of a time, it also acknowledges the fact that United Nations also has right to enforce those particular obligations, right? It has that particular thing for its officials because it has entered into certain agreements with its members. Those members are under the obligation of reciprocity, required to fulfill those particular mandates, right? So you can enter into certain treaties as well, international organization, and tasked through their constituent document, you are empowered with certain functions, powers, privileges, immunities, right? Now, in reparation case, this is where I was arguing that in United Nations was not only held international personality, but also acknowledges the fact that it will become completely redundant for United Nations. It will become indispensable for United Nations to achieve those purposes and principles that have been referred under Article 1 and 2 of the UN Charter, right? So those have been specified in Charter, and in order to make those particular purposes and principles workable, you need to ensure that UN as an organization too has right for its enforcement as well. It's been treated as an international organization. It's been treated as a subject of international law. It's been treated as an entity which possesses international legal personality. Right. So this is where the role of international organizations plays important role. Now, this is what I was referring to, that there are certain organizations like like United Nations. You also have intergovernmental regional organizations like European Union. You have ASEAN, which is Association of Southeast Asian Nations. Then you have Southeast Association of Regional Cooperation, SARC. And these particular organizations also possess some degree of international personality. We cannot claim them to be at par with other international institutions, right? But some degree of influence of these organizations cannot be disregarded, particularly of European Union. It has gained a significant amount of importance, right, over the years. Even without UK, it is a significant, organization, entity, which influence law and which also influence treaty making provisions, which also influence agreements that another state want to make with the members of European Union, right? You need to, and it has a significant role in that particular sense. So European Union is quite influential. ASEAN is also an influential organization. So is SAARC. We cannot disregard the importance of SAARC for that matter, though it has lost its significance in recent times. But every regional institution is important, strategically important reference for a particular state, right? The significance can be seen in the time or situations wherein the requirement is met. So it's a, like, even SAARC is important for that particular purpose. So these are important, right? Though they have some element of international law, does not have all the elements of international law, but they have been playing significant role in influencing law. So as a result, there are certain criteria that needs to be taken into an account. So we will refer to these criteria and thereafterwards we'll stop. Right? So as a result, there are certain criteria that ought to be taken into consideration for treating an organization, an entity as a subject of international law, right? Or within the meaning of international organization. First and foremost requirement is there has to be a constitution which must be the result of a treaty making between and amongst the states, right? You look into the manner in which ILO was formulated, United Nations has been formulated, or for that matter, the predecessor of United Nations, League of Nations were formulated, you will always come across a particular statute, which is recognized through a treaty making process, right? So this is the first and foremost requirement. Many of the institutions, including the regional institution, will fulfill this particular requirement. Even ASEAN will fulfill this. European Union will fulfill this. BRICS will fulfill this. SAARC will fulfill this. Second is certain types of functions, powers, privileges, immunities exercise. Right. So this is the second. So once an institution has been formulated on behalf of certain states which have agreed through an agreement convention that its establishment should be made, certain powers will be provided, immunities will be granted, privileges should be granted, right? And they must be in a position of exercising them. That's the second important requirement of an entity to be treated as an international organization. Third is their reference must also be made in the municipal laws of respective states who are party to its making, right, to that particular agreement. Article 104 of UN Charter, which is a kind of a treaty, which is a treaty, have reference of its organization's role in the domestic setup of the member states, right? It says that every member state has to ensure that the functions and the the for necessary fulfillment of the functions and the principles purposes that have been assigned to this institution can be made properly, should be made properly. So this is an important requirement. Similar provision you will find in the Article 39 of ILO Convention, right? So this is another important aspect, ILO statute. Then fourth important criteria is that the capacity must be, the entity must have the capacity to enter into treaty make power, right? It can enter into certain form of treaties. That kind of independence, liberty must be assigned to this particular entity. You had United Nations entering into certain agreements. The Convention on Privileges and Immunities of United Nations, 1946, is one such example. So it has entered into certain treaties with other entities, other subjects of international law. So you must have that particular capacity of entering with the other subjects. States, individuals, non-state actors, that much power and liberty must be assigned to such an entity to be called as international organization and thereafterwards possessing international legal personality and to be treated as thereafterwards as subjects of international law. The fifth essential requirement is that it must take part in international adjudication as well. Not just you have an establishment clause, not just you have certain powers, privileges, not just your recognition is being like governed, not just you have this power of entering into treaty, but also the power to enforce those like functions, also the powers to enforce if there is any violation of privileges, if there is any violation of immunities, if there is any violation of the treaty making the provisions in the treaty that you have entered into. That much power of adjudication must also be assigned to such an entity. Reparation case is a classical example of understanding all these 5 points. Right? If you look into the reparation case, each of these 5 points have been referred over there in that particular judgment. Thereafterwards, holding that United Nations is an international organization. It has the capacity to enter into agreement. It has the capacity to be recognized by the member states because it's a duty. It has the functions, provisions, it has the powers, provision under UN Charter, it has privileges and immunities through a particular convention, treaty, and then there's a statute which has aims and purposes and principles referred, and those purposes and principles can only be acknowledged, can only be enforced when there is a mutual respect for their existence among the states. Right. So international organizations should have these 5 essential criteria for their recognition as an institution possessing international legal personality. Right. So we'll stop at this. In the next class, we'll start with individuals. Any doubt so far? Okay. I will take the attendance.